All right, good morning and welcome to Mo Knows, featuring me, Monica Mo Justice. All right, let me do my sound check. You mean to tell me, girl, you a hot mess. Where's that phone at? All right, let me get my sound check on. The judge just took the bench. Mm, 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 mm. All right, hold up. Let me just go to me because I messed this all up being nosy. All right, let me check the sound again. I think the sound is great. Okay, we on deck. Let's see what the judge is talking about. Because I'm also listening for this sound. Sorry. Dean,
Yes,
can you check the feed for a minute?
what's that?
Can you-
Yeah.
I just got some regular work. All right, so they cut the fees, so we got time to chat it up here. All right, so let me make sure. Is that me? Is that the one I want? Hmm. I don't know why I went to that view. Oh, wait a minute. That's me. All right, that's me. This is the one I want. All right, but let me just shrink me a little. Do 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 do. Let me just move me over a little. Okay. All right. So we got this set up. I'm waiting for a quorum. Okay, so sound check sounds good. My mic sounds nice. Okay. So I did some due diligence from yesterday's stream. So this is the orders of the day. I don't know if we're gonna reach quorum, but I'm gonna give you the orders of the day. We're gonna go back to reviewing this trial in its current status. Um and go through it, whatever they do today until 3 p.m. So you got me here until 3 p.m. Eastern time, which will be 2 p.m. their time. When they go on lunch, we will go back and depending on what the chat wants to do, we can either revisit day one that I didn't cover, or we can go back and do the test. We can do the testimony from the person that we could go to live here. We could do the testimony of the detective or sergeant that I did not do yesterday because I did not return. Okay. As you may or may not know, I enjoy watching court cases in my day to day. So I felt like I could come here and discuss cases that I find to be challenging for one reason or another. And the reason why this case to me is challenging is because the defendant is being charged with conspiracy. And the government, or in this case, the state, has the burden of proof to show that he conspired with the other gentleman to take out this to take out the talented young Dolph. Let me see. And as the 14th juror, if you don't know, in cases like this, there are 12 jurors who are selected to decide, to be the determiner of facts and decide the outcome of the case. Then there is the 13th juror, which in Tennessee they do practice, is the judge, and she gets, in this case it's a she gets to affirm whatever the decision of the jurors are, or she gets to override the juror's decision. But nevertheless, she's the 13th juror, and we here at Momomo, at Motown, we are the 14th juror. And what our charge is just we're gonna watch this case, and I'm gonna invite you as the audience to weigh in on this trial. Together, we will dissect the drama or the testimony and decode the legal moves. And with that, I hope you have a great time as we discuss it and that we all learn something. Okay, background on this case. In November 2021, a spy, a rapper was shot down at at a local bakery, a cookie shop. And two men, this is the second trial of two. And in the first trial, there were two defendants. No, there really wasn't two defendants. There was one defendant, which was one of the shooters. And then the second defendant, which is the other shooter, took to the stand and testified against against Mr. Johnson. Mr. Johnson was found guilty, and he was sentenced immediately to life in prison, and then he was subsequently sentenced to life in prison plus 35 years. The defendant that we saw testify, Smith Cornelius, whatever Smith, you know I'm not good with names unless I look at them. He was sentenced. He hasn't been sentenced yet. He hasn't been tried yet. But he has testified. And this is the third, this is the fourth suspect. The next suspect is a Johnson. He was there was a Johnson, which was the brother of the guy who was sentenced to life in prison, the first Johnson. He was sentenced to 6 years probation. His name was Jermarquius Johnson. And the Johnson that got life plus 35 years, his name is Justin Johnson. So right now we're hearing from the state on Jovan Hernandez, and they have charged him as the mastermind behind this. So that brings you up to date with all the players who are the defendants in this case and what their status is. And let's go into the courtroom and see what they're doing.
Moves to use the CDRs for what's TZ's government name, Joshua Taylor.
Wait a minute, we got somebody going on. Man,
Harry A.
they got so many aliases around here, they ain't even crazy. Yeah, that's me making adjustments to the screen. I'm sorry. But I'm just trying to make it make sense for us. Oh, I can't do too much. Hold up. Let me just put it down here. All right, that should look good. Let's lock that in. So it was just, we know that the detective is returning, or at least if I missed it, the detective is returning. This is now gonna get locked.
I've seen no evidence of that.
Pam doesn't necessarily have an affiliation.
Correct.
I was asking you, Pam had an affiliation with or. Nobody really knows.
Okay, meantime, I'm gonna continue making my thing. Let me see. Am I missing anything else? I need one more window to be up for me while I'm streaming, because I need to see the condition of the live stream. So that will be this one. Now I tried to refocus on my stuff. Okay, that seems to work for me. Now, yesterday, you'll know I was crocheting me what I'm gonna call a bag insert. So I took it apart yesterday and redesigned the stitch that I was using. I went on a suggestion of somebody else, but that stitch didn't work for me. So I'm back at the drawing board using a basic stitch, a boogie down basic. Now this, I'm hoping, and I might have this is a protocol because I'm trying to make a bag insert for my Louis, and then ultimately a bag insert for my Neverfull, which I'll bring out here. So here's my Louis, and I believe this will definitely fit in here. Yes, ma'am, it will. Yes, ma'am. Okay. That is a good size. So what I'm gonna do with this one is it's gonna be a boogie down basic black. And then I got a match of color because within this, I'm going to make pockets inside of this. So that's where we are at with what I'm doing, where we are at in my life. That's a Mo update. Okay. You know what I should have did though?
In reverse, that's kind of how I looked at them. Ms. Taylor, what's the argument again for the court to allow him the CDR for Harry Lockhart, also known as Quinn?
Yeah. He was referenced in, well, his name was brought up as head of communication from the co-conspirator, and
Which one?
Justin Johnson.
His name was brought up in text messages or?
No, his name was brought up in Browning's testimony on that.
Okay, and what, I mean,
As having some, this was on July 27th. It was in reference to Justin texting him about talking to Juke, and it's also, I believe, relevant.
July 20.
Defense brought in first name, they indicated that, Justin was doing not just, I'm sorry, Joshua Taylor, Harry Lockhart, I'm sorry, all names starting to get confusing. Harry Lockhart, was talking, or was referenced in some of Desmond Sticks Institutes in regards to.
It's not that the names are starting to get confusing to this DA, it's that they are not familiar with their case. They just thought this was going to be a walk in the park and they wasn't going to be able to get a real challenge from a defense attorney. This defense attorney came in with all boots on the ground, explaining to the jurors and captivating them, or at least I believe, with the fact that there is reasonable doubt that his client was a co-conspirator and or a mastermind in this assassination.
You said specifically on July 27th,
Yes,
as we were going through text messages on yesterday.
no, he was brought up, in Brown's testimony
Right,
in regards to July 27th.
so what I'm saying.
That's what the judge said.
Just from Justin Johnson.
But that's what we're talking about. We're talking about, so, we're talking about Justin Johnson's communications with Harry Lockhart.
On yesterday is how Harry Lockhart became relevant. And it's also referenced in Justin Johnson's text message to, I think, another individual
About Harry Lockhart.
about Harry Lockhart.
Okay, so my question to you is that when Sergeant Browning was testifying yesterday going through his PowerPoint, was
He shouldn't have had all that on the PowerPoint.
mentioned on the 27th? Did you referenced the 27th?
Yes.
And you think it's relevant now? Because I'm sure that's what your argument is going to be. I didn't necessarily get that from you. Is that your argument that it's not relevant?
Yes, Your Honor, just like yesterday, it's just a passing reference to the text. There's no communication that we introduced to
Right.
him. And you suppressed that yesterday because that's
Well,
the point.
I got that, and I agree with what I just read, that it is just passing here. Ms. Taylor just brought up another argument, but that it was brought up in Sergeant Browning's testimony yesterday, that there were conversations, on text message, from Justin Johnson to Harry Lockhart, that she says is relevant because Harry Lockhart's name came up yesterday.
Okay, but what is
They
it?
brought it up. It just happens to be a passing thing across that we're giving a text message. You can point it out wrong right here. I didn't need this data there. I'm just giving you the text message because Justin Johnson was talking to somebody else and he says, oh, Pam's there too. That's essentially all that is to it. It wasn't relevant and direct when we talked about it yesterday. We didn't bring it up. We didn't emphasize it. We didn't do anything. I don't even know what Ham has to do with the price of tea in China.
But it's now in the text messages that she banned.
It's
That's the fact that you highlighted some text messages, okay? They said that you're making the argument that.
He highlighted text messages yesterday, from my recollection, to indicate that his client was not the mastermind, that the individuals that engaged in the heinous act of the assassination acted in and of themselves, right? They acted in concert with other people, or may have been in concert with others and not necessarily his client. He introduced reasonable doubt or alternative co-conspirators, and the district attorney's office, of course, is not happy with that, and I guess they want to elaborate further on the messages between those people to either, well, I'm assuming because they want to bring it up to quash that issue.
Justin Johnson having individual conversations outside of Govan, Mr. Govan, about other issues, about
I'm not,
whatever they were talking about.
I'm not highlighting.
No,
On
you're
direct.
you're highlighting.
Well, it's in there, but
Yeah.
on direct, they brought it up, the Justin Johnson
I'm
text.
saying, but you've now highlighted it, and so. Ms. Taylor, what's your response that it's not relevant?
He didn't highlight it. It was on their demonstrative. If they had not introduced it on their demonstrative, he'd have had no reason to bring it out to the light.
Here. But it can be whited out for our citizen firm.
Well, now they want it whited out, they even did that yesterday and they could have done that then. But also, Your Honor, I would, further state that there are communications between Mr. Goldman and Mr. Lockhart during the time of this conspiracy.
Look at the judge's face. I hope y'all can see it. It's all like they could have highlighted it and whited it out. This is your demonstrative state.
Which and they're gonna, it's just, may have been doing some outside things. It's important for the jury to also know that Mr. Lockhart had communications with Mr. Goldman.
Judge, they brought up the communication between Justin Johnson and him. They brought it up in their text message. It was already there. So when I'm crossing in with some of these other text messages, that guy's name is referenced. We didn't bring any other specific text messages between.
So what the state is arguing to me is something called completeness. They want to show the complete record to close the story. That's what I believe I'm hearing here.
Justin Johnson. They brought it up. He wasn't relevant to that yesterday. It was a very lengthy direct examination. It's one of their slides out there that says Justin Johnson talked to him. They brought it up. I didn't ask him again. I just read the text message like you start to get again. What needed this done? It has nothing to do with anything as far as that goes. They brought it up. And I'm just responding to that. It wasn't relevant.
And these are arguments. These are arguments outside the presence of the jurors.
Forward, and they're coming into another business, these are self-authenticating documents that are relevant to this trial, specifically to Mr. Goldman. If their argument is gonna be, which they asserted several times yesterday, that Justin Johnson is going outside this and he was talking about Ham and referencing Ham and sending information about Jude to Ham. It's also relevant that Ham or Mr. Lockhart has communications with Goldman, and it's not outside of the scope of this, of the, conspiracy.
They're conflating the issues. They brought up the fact that Justin Johnson was talking to him on direct examination outside the scope of the conspiracy. My text messages don't have any communication with him. It's from somebody else. If they want to bring in the TZ stuff, I agree, but I put in a text between Justin Johnson and TZ. Now, it's the same argument we went through yesterday on chat. They brought up the text. Now she's making it seem like we somehow manufactured something out there. They brought up the text, indirect, that Ham communicated with Justin Johnson.
This is why they should have shown all the text messages. It was kind of convoluted.
And I was under the impression that Ham was mentioned, and I'm looking at exhibit 26, that Ham was mentioned in this text message from Justin Johnson to TZ, Joshua Taylor. I'm going to slow down. As to Harry Lockhart, also known as Ham, in my shows.
We have no objection to the TV one, based on that.
Let me give you the TV, Joshua Taylor, CBS.
Thank you.
Say it again.
Nothing for Mr.
All right, so we getting ready to bring in the jurors.
Is your medical opinion? I'm gonna put her on.
Well, I would just say I have no further questions for Sergeant Brown.
Okay.
I don't know here.
Yeah, he can be released.
I figured that was the next. I figured that was the next test that was the medical examiner. So what's gonna happen is they're gonna do the medical examiner. They're gonna do the medical examiner, followed by then the state is gonna rest their case. This is what we heard yesterday, and then the defense is probably gonna bring a motion for directed verdict, saying that they do not have enough evidence, that their prima facie case did not align with the charges against their client, and see if they can push any of those out. The judge yesterday gave an indication that she was going to deal with jury charges, so I believe that that's going to be a moot issue, as it traditionally is in cases. And then they're going to move forward with the presentation of the defense's case in chief, if they have one to bring, and they indicated that they did have witnesses to bring out. This is the most movement I've seen with this defendant, or engagement or interaction I've seen with him. So maybe he's feeling a little bit more comfortable, because he's about to enter into the phase where he gets to defend himself. But we'll see. So again, we're just waiting for the jury to come out. Make sure you hit the like before you take a hike,
Ready to go.
so we can push this video out to the public. Psych. In the last case, the medical examiner was a female, so let's see. Or the last trial, because it's the same case.
You should know that Sergeant Browning was excused, yesterday without any further. Argument with. State calls out that Juliet's been married.
That right here, ma'am. Face your arm, raise your right hand.
See, we're not from each other too.
Hey.
Thank you for your presence.
Oh, looks like the same lady to me.
Could you spell your name for the record?
My name is Dr. Juliet Scantlebury, Juliette, Scantlebury, Scantlebury.
And where are you employed?
At University of Tennessee, at the West Tennessee Regional Forensic Center.
And what's your position?
I'm an assistant medical examiner,
How long have you been in that position?
6 years now.
And what does your job consist of?
The job consists of performing medical legal autopsies to determine cause and manner of death in certain cases in this jurisdiction.
I want to talk a little bit about your background. Could you tell the jury about your education?
Yes. So I completed a Bachelor of Science in Biology at Howard University. Then I completed my medical degree at Howard University College of Medicine. My anatomic and clinical pathology residency was at Washington University in St. Louis. And then my last training was in forensic pathology fellowship at St. Louis University.
And are you board certified?
I am.
And are you a licensed physician in Tennessee?
I am.
And could you tell the jury what is forensic pathology?
So forensic pathology is a specialized branch of medicine that examines deceased persons to determine the cause and manner of death in a medical legal approach.
So what does a forensic pathologist do?
So a forensic pathologist performs autopsies based on the jurisdiction that they're working in to determine the cause and manner of death for certain types of cases that are under our purview.
And what exactly is an autopsy?
So an autopsy is an extensive examination of a deceased person. You have an external examination and an internal examination of the body. So you look at everything from hair color, eye color, their body habitus, if they have scars, tattoos, that's the external examination. And then the internal examination, depending on the level of autopsy, we'll look at all body cavities, we'll weigh all organs, we see if there's any fluid or any evidence of disease in any organs. And we also went ahead and look at the brain and take certain fluids to be able to test to determine by toxicology or histology to determine, and with all that together, we determine what most likely caused the death for a brain or particular autopsy.
So Dr. Scantlebury, are there different stages of an autopsy? And what are those stages?
Okay, the autopsy itself is looking at the body, but starts from the investigation. So the investigator will give us the information, and the information we get from the investigator determine what type of autopsy we need to do. And if they're determined that a full autopsy needs to be performed, we might need x-rays, we do that first. Someone will help take all the clothing off, if there are any, take necessary pictures, necessary measurements of the body, the height, weight, and any other identifying characteristics on the body. And then move on to the internal part, and that's where we'll make an incision to be open up the body cavity to see the internal cavity and see all the organs and any changes that might have happened that might be related to death or otherwise.
Have you performed an autopsy before?
I am.
About how many would you say?
Over 2,000, I stopped coming after that.
So could you explain to the jury, what does cause of death mean?
So cause of death is the immediate reason that led to a person's death. So it may have different ways of saying, so if it's natural, it will be what medical disease led to the person's death, or if there's any kind of injury that caused the person to no longer be alive.
And is that different from manner of death?
Yes.
How is it different?
So manner of death is the classification of that type of death it was. So it will be how you would want to classify the death. So there are 5 manners of death in this jurisdiction. It may vary in places, but here is natural, accident, suicide, homicide, undetermined.
And have you ever testified about your findings from an autopsy you did?
Yes.
And have you ever been qualified as an expert witness in the area of forensic pathology?
I have.
And have you been qualified in the courts of this county and other counties?
I have.
Where have you been qualified before?
Illinois, Missouri, and Tennessee.
Your Honor, I extended Dr. Stanberry as an expert in forensic pathology and asked that she be allowed to state her opinions as to a reasonable degree of certain medical.
No objection.
The court will find that Dr. Stanberry is an expert in the area of forensic pathology, therefore she can testify as to how you know that you did those things.
Thank you. Dr. Stanberry, I want to ask you about a specific autopsy. Did you perform an autopsy for an Adolf Horn Jr.?
I did,
And do you recall when this autopsy was performed?
yes.
When was it performed?
November 2021.
Okay. And during the course of conducting this autopsy, did you also take pictures of Mr. Horton's body?
Pictures were taken.
No objection, Dave.
Okay. Passing you a few of the pictures from this autopsy. Dr. Stanberry, do you recognize the photographs we just handed you?
I do.
Okay. And do they accurately depict the victim and the evidence during the autopsy?
They do.
Your Honor, I would like to have these photos of the autopsy entered into evidence and marked as next to the exhibit.
Well, she needs to specify about what they are.
If we could enter them as a collective exhibit,
Well, that's fine, but she still, for the record, we need to know what they are. She needs to specify each one individually.
okay.
And you don't have to publish them, that makes me no difference, but she needs to tell us what we know.
Dr. Stanberry, if you would look at that first picture, what is shown in that first picture?
So this first picture shows the Mr. Thornton on the right side of the body, with some of his head and his right shoulder, and it shows some gunshot wounds of his right jaw, right neck, and right shoulder.
What about the second picture?
This is a shot of his right upper extremity of gunshot wounds of the right forearm, so here.
What about the third picture?
This is another shot of the right side of his body, mostly with the right arm, and it shows his right hand, and there's a gunshot wound of his right wrist, and it shows another gunshot wound of his right forearm.
And then so the fourth picture,
This shows some other gunshot wounds of his left upper extremity.
and the fifth picture.
So this picture shows the back of Mr. Thornton's body, and you can see both arms and his back, and you see the.
For those just joining us, this is the medical examiner.
And the sixth picture,
This is another picture showing the same thing, but it was taken.
She's describing the photos. She has been deemed an expert, which means not only does she get to give you, does she get to present the jurors with what she did in the autopsy, but she gets to give her personal findings as well.
Two of the bullet fragments that were recovered from the right jaw from Mr. Thornton.
and the ninth picture,
These are bullet fragments from the torso from Mr. Thornton, picture the bullet fragments.
and the 10th photo,
This is a remote, shows a picture of the remote bullet from the left thigh.
and the 11th,
This is a remote bullet from the right lobe of the liver.
and the 12th,
This is a bullet core fragment from the right chest.
and 13th,
This is a bullet from the lower mid back,
and 14th.
and this is a remote bullet from the right thigh.
Your Honor, we'd like to have these photos of the autopsy entered as a collective exhibit.
No objection, Diane.
I don't like this, collective exhibit. The first bedroom pages are moved.
So now the judge is describing the images so that she can mark them as exhibits in the official court record. So she describes each image, or it looks like she put it in a cluster here.
His body, a full mark is a collective exhibit. 31.
Karen Barry, we're gonna start with the first photo that you view. Could you tell us what is seen in this photo?
So in this photo, you can see the right side of the burning body. That rectangular object is the case placard with the case number associated with this case. It can be seen. This will help you attach that photo to that particular case. And so, and you can also use the scale for the wound or anything you need to measure on the body. So on the right side of the body, you see those defects in his right jaw and right neck. Those are gunshot wounds of his right neck and right jaw. And then there's some gunshot related injuries of the right shoulder.
Did you have any specific findings as to this injury?
Yes.
What were those findings?
So the injuries of the right jaw and right neck cause injury to the tongue and skeletal muscle on the right mandible, which is the lower part of your jaw. Those were injured.
Moving on to the second photo that you viewed. What is shown in this photo?
This is the photo of his right arm. So to the right of the image, that is his right arm. And most of what you can see is right forearm. And this is the front side of it, the anterior portion. You can see those two large defects are gunshot wounds.
Were there exit wounds on this part of his body?
Not the one, those are, kind of graves or tangential wounds.
Move on to the third picture. And what is shown? I'm sorry. What is shown in this picture?
This is a photo of the right side of the body, and you can see a gunshot wound in the right wrist. And another defect, a little earlier, smaller defect.
Moving on to the fourth picture. Could you tell the jury what we see in this photo?
So this is a photo of Mr. Thornton's left forearm, and it shows a gunshot wound and some gunshot related injuries of the left forearm.
Moving on to the fifth photo. What do we see in this photo?
So this is the backward view of Mr. Thornton. His head is to the right and his feet are to the left of the photo. And you can see his arms, you can see some of the same gunshot wounds you saw in previous photos, but on the back view, you can see the overall view of the gunshot wounds of the back.
Okay. And moving on to the sixth photo.
This is similar, but from the left approach of the body, you can see its overall view of the gunshot wounds of the left, up the back.
And the seventh photo that you do?
This is a closer view of the gunshot wounds of the back from the left side of the body.
Okay. So in total, how many gunshot entrance wounds were there on Mr. Gordon?
Definitive gunshot entrance wounds, 20.
And were there any exit wounds?
Definitive exits, 4.
Okay. And moving on to the eighth photo. What do we see in this photo?
So these are bullet fragments of the right jaw. These were all the larger fragments that were able to be recovered from those wounds that you saw in the right neck and jaw.
And that was from the first photo that we did.
Yes.
Okay. The ninth photo.
These
Oh.
are fragments.
I thought they was about to sell something I don't want to see.
And the tenth.
This is a remote bullet from the left side.
All right, and the 11th photo.
This is a remote bullet from the right lobe of the liver.
And the 12th photo.
This is a bullet core fragment recovered from the right chest.
And the 13th photo,
This is a bullet from the lower mid fat.
and the 14th photo, what did you see there?
This is the underside of a bullet base that was removed, that was recovered from the right butt.
Can you describe to the jury, what is a remote bullet?
So remote is what people use different words can say remote or old, but I choose to use remote. Remote means it's a bullet that is related to a previous injury, a previous shooting, not the shooting that led to their death. In this case, it's happened before.
And how many, or do you recall how many remote bullets you might have found?
They were
So, Dr. Scalberry, within a reasonable degree of medical certainty, did you render an opinion as to Mr. Ford's cause of death?
they did
And what was that?
gunshot wounds of the head, neck, and torso.
And did you render an opinion as to the manner of death?
I did
And what was that opinion?
homicide.
Your Honor, I will pass the ball.
That's it?
Two questions here, with Dr. Silver.
Wow.
Okay, with it.
That is the state's proof, with the exception of the, go ahead and read that.
Oh, that wasn't on stipulation.
No, it was,
You don't stipulate, so there. Oh, that's no problem.
Did we already put it in? No, we talked about it, we have, it in the evidence. So ladies and gentlemen, there are, when you go back to deliberate, you will have everything that they entered as an exhibit. There are at least two documents or two, exhibits that you haven't necessarily heard, specific proof about. They are called, what you might have heard is CDR, called detail records. The law will allow, certain records to be entered into evidence without testimony about them. And so that's what Ms. Taylor is getting ready to enter into, evidence now. It's been reclined by the state. And there was one that was entered yesterday also. So you'll have a few things that you can review, but you haven't necessarily heard testimony about.
Text pictures, self-authenticating, documenting, like.
Now the defense got to make sure when they put on their case that they don't overwhelm and bore the jurors.
Self-authenticating document for phone number 901-283-3878. From T-Mobile, attested to by Joe Rico. Also, I have here this drive, a blue zip drive. It has Joshua Taylor's name on the outside of the envelope, and it has CPR, so these are the call detail records for one Joshua Taylor with interview as collected and visit.
on the bed is mistake.
Ladies and gentlemen, we need to take a brief break. We're coming back in just a few minutes. haven't heard all the proof. Continue to do what I know you've been doing, which is not talking about this case. So the community got to keep legal things to take care of, and we'll come back and just.
Now it's 11:30 our time, or close to 11:30. The defense had predicted that 11:30 their time they would be starting to put on their their case in chief. So it's 10:23 in their time. They are an hour behind us in New York. They're on Central Time.
Yes, Your Honor. We are very, very understanding that, Mr. Cornelius has given some statements about it, that he was warned to do it. I don't know if that rises to the level of a conspiracy or agreement of parties. It was very inconsistent as far as that goes. Secondly, there's been no mention of how Justin Johnson is part of the conspiracy at all whatsoever. I understand it only takes two to tango, but I just don't see where the proof adds up to the conspiracy, and certainly not the first degree murder charge in count two, based on the evidence you've got.
That's it?
Your Honor, the court is to view the evidence in the light most favorable to the state. We've heard testimony from Ms. Thornton that Mr. Thornton, the victim, was alive, is no longer alive. We heard testimony from Dr. Juliet Campbellberry, who testified as to the cause and the manner of death, which is homicide. We also heard from a few other witnesses, like Amelia Smith, Angel Arnold, stating that Freddie Nizzo is the one that told Ms. about this hit when Mr. Thornton, and told him about the car. So all that to say, Your Honor, and also, Your Honor, that Justin Johnson was involved in the car. So all that to say, the state would argue that there is enough for a reasonable jury to acquit.
I have no critical force use alive since passed. You've heard proof that they didn't communicate for 2 weeks, at least with Justin Johnson, at least 2+ days. On the phone calls that the government submitted yesterday, Cornelius Smith. Supposedly last phone call was on the 15th of November, 2 days prior to the murder. It was for 0 seconds, and then there was that code 11 that Garner talked about, might have been voicemail, that was 40 seconds. We know for a fact that he didn't talk to Justin Johnson based on the phone records for at least 2 weeks prior to the shooting. You're being asked to make a lot of supposition here based on what Cornelius Smith said. Cornelius Smith also said there was no plan. He got a call that morning, they got there, they were just riding around doing whatever. Now, the fact that somebody 3 to 4 months prior to that fact said to you that maybe a price on somebody's head, and was it Justin Johnson? I'm sorry, was it Bill Van, or was it Joe? You've heard both things from the same witnesses have said it both ways in uncontroverted evidence. And so I'm not sure, how do you have a plan when I say, hey, there's a hit on these people? Some point in the future they kill them, now on the hook for it. I just don't see how that makes a conspiracy. Generally, there's competing minds as to how, to, what, went where. Nothing happened. It was just generic. If you believe proof, 4 months prior to the shooting, it's a generic statement that, hey, there's, these guys beat the campaign.
Anything?
Not a strong argument, but
I prefer to state the court has heard from different witnesses that have been some conflicting testimony. However, the court thinks that there is, the state has made a compensation case for both, conspiracy to commit first degree murder and first degree murder, and, get the jury question. So I'm gonna
judges do not like to do directed verdicts. He's getting his witnesses together. I think personally, I would have practiced that the night before and wrote up a better this is one thing about being a seasoned defense attorney. you know how to present your oral argument, and I realize that that's what this is. You know, they are seasoned attorneys. They know how to present their oral arguments. However, I would have preferred a as as the person on trial, I would have preferred a better oral argument being made on my behalf. I'm just saying. That's just me. That's how I see things. Because you want a person to be like, I want you to earn your ducats, even though I think that this attorney has done a great job developing doubt or emphasizing that there are no connections between his client being, in their words, the mastermind of this conspiracy. And I do believe that just because somebody had a conversation with someone and said that um, there was a bounty on someone else's head, doesn't mean that they're part of it, but that they were the mastermind and encouraged you or in furtherance of the crime that you engaged in it. However, um, what the prosecution or what the state was able to present is two witnesses, one being the other shooter himself, who is waiting for a deal, and he's told in this testimony here, he basically said he's waiting at limbo. He don't know what's going to happen to him because no promises have been made for his testimony, but he believes that he's cooperating and that will be favorable to him. The sentence for murder in Tennessee is life in prison without the possibility of parole. And then, this guy has an extensive drug history. We're talking about Cornelius. But Cornelius to me seems a little bit bitter if he really did enter in this agreement with Jovan, with Hernandez, Jovan. He's basically saying, yo, you ain't pay me or see to it that I got paid, and thus um I snitched. But the thing I find interesting about this matter before us is that Jovan Hernandez is being accused of being the mastermind, parking or knowing that they parked the vehicle across the street from him. So basically giving the impression that he had eyes on the vehicle, and the best they was going to do was either burn the vehicle, chuck it, or they were going to cover it um with a cover, which out of all of the people involved that are the four defendants, the one that was purchasing the cover is the same man who did the snitching. I feel in my bones that the snitch, which is Cornelius, at this point, Mr. Smith, I think he played Mr. Smith Jr. I think he played more of a role in being a mastermind than anybody else, and he was able to flip on everyone to get the best or what he deems to be the best deal possible. We don't know what that deal is going to be, but he definitely felt that it's favorable to him. Um, Having the car parked across the street is crazy to me. It's crazy work. The other thing that doesn't make sense to me that was part of the government's case is that Cornelius needed to get the phone out of the car because he left the phone in the car. I would have liked to have seen the phone logs line up with him being there at the car or retrieving his phone and having some fingerprints of Gavin, Hernandez Gavin, or whomever got the phone out of the car. And did he get the phone? I'm not clear that he ever redeemed his phone per se, because future calls was made through his girlfriend. Um, and I believe her name was Angela. And honestly, I feel like Angela, I don't know why this AutoZone thing is so important, but it's extremely important to the defense. So I hope they make that connection to for us. Maybe they've got video, maybe they've retained the video of what happened when these folks walked in the day after and purchased the cover. How do we know it's the day after? Because the testimony yesterday that we did not hear on the live stream, but I did view last night from the detective Brownie, he basically said that the evidence showed that there was some cell phone searches for a 24-hour AutoZone. This was in connection with purchasing the cover for the vehicle. So that means the vehicle was not covered the first night of the incident. And that they were, so this is contrary to the testimony that was given by Angela. uh they they actually collected or purchased, whomever it was, because if you listen to Cornelius, Angela purchased it. If you listen to Angela, Cornelius purchased the cover. Who can't remember who purchased the cover? But what we do know is that Cornelius did research on when, in the middle of the night, sometime around midnight, the day after the shooting, for an AutoZone that would be open 24 hours. He did not find one. At 7 a.m. in the morning, he woke up again looking for an AutoZone, and he was able to purchase um a cover that they believe that he purchased, because there was some issues with the receipt, that they purchased one the following day. Um, so timelines will probably be interesting in this case, but timelines specifically that shows that Hernandez Joven was the person who initiated some of this engagement. If the government is only going to say, listen, he told them about it, and let's be clear, there was some kind of transactional relationship between the defendant Hernandez Govan and co-defendant Cornelius Smith, which there was some kind of transactional error, some kind of transactional activity in terms of how he got his drugs. So I don't know. He just seemed like a send out guy that that when you dealing with these people that are addicted to things, right? They will do anything to chase that addiction. Offer up their services in any way necessary. You don't even have to invite them to do something. They're encouraged to do it because they have to feed that habit, feed that addiction. And I believe, based on the information that I've seen so far, that may have been that may have been at play here in this in Cornelius' fast talking plan, because all he's trying to do is get to the next hit, get to his next activity, unfortunately, his next personal moment. Unfortunately, I hope that he's able to find peace in his life, but I wouldn't have went out on this level. If you know you did something, so I can understand him wanting to take everybody down with him, but there comes a level of loyalty. And if you listen to his testimony, which we'll go through if we have time today, you will see that he did not want to disclose the names of other people who sold him narcotics throughout this same period of time and so on and so forth, because he said they were not affiliated with this case. So he was very clear on wanting to take out people in this case. I'm kind of wondering if he was working all sides of the fence. But who knows? This is weird, and we'll see. I don't really like to speculate. I'm just giving you my opinion on the things that I've seen thus far in the testimonies that I listened to. Anyway, we will just hang out here. I'm still crocheting along my insert, but I need to figure out how high I need this insert to go inside the bed. We know we about halfway there on the height of the insert. I'm so excited. I'm about to make the as I'm doing this, I'm sitting here trying to contemplate how I will do the pocket, cuz I want a pocket. I want to have a pocket for my pens. Like I want to put my pen on the side. I got to figure it out, but I'm going to lay it out cuz I'm going to lay out space cuz I need to have certain spaces in here for things that I carry. My keys need to go in here. My different small leather goods need to have a designated place for them, and I'm gonna make spots for them. I'm gonna carve it out and make spots for them. Now I do have an insert, but it is not in this bag. My insert's in one of my bags, but that's hold on. Actually, I want to send a text message to somebody. Yeah, I mean this is definitely gonna fit my wallet. My wallet is gonna fit in here. See how my wallet is about the height of the wallet now, so my wallet fits in here. So it's it's getting there. Okay, let me. I want to text somebody. Where's that phone? Where's my other phone? Here it is. Oh wow, this is a big break. Well, they're waiting for the defense's witnesses. Okay. Now, I only had time this week to do live coverage, but in the future, I'll just be doing the afterplay coverage. I just figured I'd try this out and see how it fit me or if it didn't fit me. To see if it's something I'm gonna do in the evening time when I do have time as a recap. All right, hold up. I'm still texting a message. Hold up, I'm having a whole conversation about the thing, but we're waiting for them to come back. Let me just let y'all see that we're waiting for them to return. I didn't want to continue to have something up. We're waiting for them to come back from the courtroom, but we would hear the sound. Okay, we back. We back live in the courtroom, giving our commentary here on Mo Momo. We are covering the case of Tennessee versus Hernandez Govan in the conspiracy to assassinate young Dolph. Okay, let me see. We're waiting for them to come back. Okay. So we're still waiting for them to come back in the courtroom. I was just having a conversation with my crochet buddy. And I was telling her where I was at, and like I'm on round 20. 1, 2, 3, 4, 5, 6, 7, 8. Yeah. I'm on round 20 on the round, but I'm not gonna go all the way to 52, but I am gonna make the handle cutouts and then go around. So I gotta figure out how I'm gonna do that. So I gotta because I'm gonna need the handle rounds to put it inside of the bag. So I'm gonna need two handles. So what I plan on doing is making it up to a certain height, and then somewhere in the middle here, doing a handle on both sides so that you can pull it in and out of the bag without there being an issue. And then come in with the inside and make pockets on the inside. So I don't know if that means making an insert and sewing it on, which is more than likely what I would do, so that it can have movement. Ooh, that scared me. I'm telling you, the defendant looks more relaxed today than he has in any of the days that he's been. Well, it's only been 2 days. But this is if he's found guilty, this is a hell of the rest of his life.
Yeah, let's go back on the record,
Court's back in session.
bring the jury back in.
I have to make sure I keep doing my counter on this. I have a counter on my phone when I'm doing the every time I do a round, I'll be forgetting to hit it. I'm waiting for her response and then this thing is crazy. You know what I meant to do? Oh, I don't want to touch that. Okay. Okay. Mo, be nice. That's all I can say to myself is just be nice. Just be nice. Who they call?
There, raise your right hand.
Oh, law enforcement.
Yes, ma'am. Can you please tell us your full name, spell out your first Last name. Michael Coburn, MICHAEL, And I see the lieutenant bars in their uniform. Could you tell this jury where you work? I'm currently assigned as a supervisor to crime scene. And with what department? With the Memphis Police Department. And how long have you been a police officer? Almost 28 years. And how long have you been doing crime scene analysis, I guess? About 15 years. Have you been qualified as an expert in crime scene analysis in the past by the state? I have. And you testified as an expert? Yes. Have you testified in Shelby County as an expert? Yes. Crime scene analysis meaning you
I'm
look for
speechless.
blood, evidence in cars, houses, stuff like that? Yes. And that's what you've been qualified on behalf by the state in many cases in the past? Yes. Your Honor, move to have Lieutenant Coburn admitted as an expert in crime scene investigation.
Lieutenant Michael Coburn as the expert in crime scene.
Yes, Your Honor. Back in 2021, I think you were a sergeant based on the reports, is that correct? I was assigned to homicide. And were you doing crime scene with homicide back in 2021? I was. And did you happen to work on the crime scene analysis for the murder case of Adolph Thornton? For vehicles, yes. Okay. And did you specifically process a Mercedes-Benz vehicle in that case? I did. And was that car recovered, and I guess you looked at it on November 20th of 2021, is that correct? Yes. Okay. I'm gonna show you a few photos that have previously been marked into evidence, and just make sure that's the same car. Okay. Whether Robert will do that. We're gonna put in exhibit 11 that's previously been marked in it.
I'm speechless. Shiver me timbers. I'm speechless.
Next. Exhibit 12, the 12, 13, and 14. I just want to get the jury acclimated to the car. Close up view of the car. Yes, sir. Same license plate, everything. Yes, sir. Okay. 13. Yes, I said we're going to do 13 and 14. Just a front view of the same car. Yes, sir. Okay. Same thing? Yes. All right. And then where do you process the car? At Forsyth Park, right? It's a warehouse. Okay. So I guess it gets towed over to the police warehouse? Yes. All right. With regards to processing the car, can you tell the jury what exactly you do? Primarily we document evidence, collect evidence. When we process it, we usually process for prints, touch DNA, and just evidence like clothing or something, anything the investigators look for. You also look for blood? Yes. You also look for evidence of somebody trying to clean up the crime scene? Sure. All right. So with regard to this Mercedes, I think they used to call it luminol, and that's what you hear on TV, but it's Blue Star now, right? That's what you guys use to look for trace evidence? They use Blue Star because luminol requires more darkness. Blue Star does. And Blue Star was used in this case? It was. All right. So without getting into the nuts and bolts, you process this car with Blue Star? Correct. And if I were to tell you that a witness has said that he took a towel, put a bunch of bleach on it, and wiped the car down, is there any evidence of that in this case? No. And you would see that with the luminol, that there's bleach and things like that, as soon as you're here, crime scene. Yes. Okay. Because otherwise people would get away with anything. Right. Did not happen with regards to this car. No. So if I had said under oath, I got bleach, put it on a towel, wipe that car down, complete lie. Yes. Thank you. No more questions.
He's discrediting Cornelius Smith. That's basically where we're at. He's passed the witness to the prosecution. Sergeant Coburn is um a Memphis officer, and he was involved in gathering evidence from the vehicle in this case. And he was called on behalf of the defense. So remember, if the prosecution had called, oh, lieutenant now.
You didn't find any print on the front passenger, outside of the vehicle sticker.
I'd have to look at the, I'd have to look at the summary of it.
So I guess she's gonna try to prove that he could have wiped it down. That's why there was no prints on that side of the car, the passenger side of the car. But what the defense brought him up to testify was that there was no evidence that there was an attempt to remove the fingerprints from that side of the car either. So just because none were found, what the defense brought him up here to testify for was to evidence that there was none removed either. No evidence of bleach and whatever other chemicals homie said he used to wipe off the side of the car. Just because the guy told whoppers doesn't mean that he wasn't present for the execution style takedown of.
Matt Johnson, did you process the inside?
I did,
Did you find any print about the inside?
didn't say without looking at the narrative. No, there's a lot of print cards. There's a lot of print cards, so that it.
Oh.
So that's what we put them prints on.
Did you find Mr. Covens? That's under him. But you ain't find Mr. Covens fingerprints either. And he was alleged by their witness, by the state's witness, to have went in there and collected the cell phone for Mr. Cornelius Smith. All right, let's see who this next witness is.
Or affirm to tell the truth.
Yes.
Have seen him what you said.
Good morning, Ms. Ferguson. Would you tell the jury your name and could you spell it for me?
My name is Vivian Banks Ferguson.
And could you spell that just so the court needs to get it right? Your first name, middle name, and last name.
B-I-B-I-E-E. B as in boy, A as in right? First, that's the F-E-R-G-U-S-O-N.
Ms. Ferguson, how old are you?
80.
Okay, I'm not never supposed to ask that question, so I'm sorry. Do you live next to Cornelius Smith Senior?
I live next to
King Smith, his dad.
Okay. His daddy, King Smith, lives next door to you, right? And you have to say yes or no, I'm sorry.
Yes,
Alright. And Cornelius Smith, that's somebody you know, right?
yes.
Could you tell the jurors how you know Mr. Cornelius Smith?
He's a young man that lived next door, and the only reason I had came in contact with him, he always would do nice things for me, like when I go shopping, he always would get my grocery out the car and bring it in the house for me. That was good for me, cause I was tired. So, that's not only that, that's the only time that he come around, if I need something done, I could ask him, and he would do it. And, if he charged me, I would pay him, but he never charged me for anything. To me, he was a nice kid.
So, Ms. Ferguson, you and I talked at your house last week, just a few days ago, right? You'll have to say yes or no.
Yes,
Alright. And I also asked you, if Cornelius Smith said a few years ago, that somebody came by your house to get you $500 for things, would that be true or false?
it would not be true.
Holy crap!
That under oath. that You're like a grandmother, right?
If that's what you want to say,
Okay, I'm just repeating what I've heard in the court, so. If he said that you got $500 for him to hold, never happened.
never happened.
Not yesterday, not 5 years ago, not 10 years ago.
Now, if somebody was gonna leave something for Cornelius at my house, they probably stuck it in my mailbox or something like that, but I haven't received any cash or any envelope from him.
So if somebody said you were specifically given $500, would be a lie.
Would be a lie.
And I'm really sorry to call you. I know the last time you came to court was talking about your son's murder, so I 100% apologize. I know you were very upset at that. So thank you for your honesty.
Another witness to discredit Mr. Cornelius Smith. No questions from the prosecution.
Someone we have come to that junction where you have heard all the proof, but there's still one more piece with that you don't have. And that is the law that you're going to get from me. So give us a few minutes. We'll get back to you, so please don't disturb. Right? Thank you.
You're under accused.
I don't know how to feel about this. I was expecting a little bit more something. I'm gonna mute this up, and if there's some activity, I'll come back to it. I don't know. I don't know how to feel. I feel cheated. I feel cheated. Ooh. And let me just say this, from both ends of the spectrum with Miss Ferguson's testimony. She said she never received no money, but doesn't mean that no money never took place.
Let me get the stipulation, sorry.
That's
Sounds like there's a stipulation going down.
What's next over?
I'm great. Sorry, great. Mr. Aurora.
Yes, sir.
I need you to put the client on the stand. We need to go a moment to do for sure. This is the time to do it. Come on around, Mr. Governor.
All right, so this portion, this is the portion where they make sure that he did not want to take the stand and that he made that choice.
work.
Go there, would you please spell your first and last name for the record?
HDRNAMTUV
Mr. Govan, you and I have talked about your right to testify at trial, correct?
Yes, sir.
I've advised you and I would recommend not testifying based on some of the evidence you're ruling. Is that correct?
Yes, sir.
And you've agreed with me that you do not wish to testify.
Yes, sir.
That's freely and voluntarily. Nobody's forcing you to do that.
Nobody forced me.
Nobody's threatening you to do that.
No, sir.
All right, and this is something you are doing freely and voluntarily again.
Correct.
Yeah, stand with 33 hours. Stick around.
Okay, that's always done on outside the presence of the jurors because the defendant has a right to remain silent.
They label, what are labels for that? I mean, so they'll know which line is which.
The two that overlap, Your Honor, essentially it's the same. Theirs are just a few seconds longer, so they should be able to figure it out pretty easily.
Then, when I,
Okay.
they label,
Ours are labeled, they will have, I believe they have initials, so like it's an Angela arm flip, it will say AA, and then whatever the contents, joke or.
right, okay. As long as they're labeled somehow, they're just not just clips with nothing, other than what's the numbers on.
Yeah, they're labeled so I can find it, so.
All right, this is, order stipulated to the police interview, soundbite that were testified to on yesterday, by, witness Angela Arnold.
Angela Arnold, Cornelius Smith, and also the detective, we played parts of sound bites from the interviews of all three.
Okay.
Yeah, Detective Browning, I'm sorry, said Smith.
And the stipulation reads that whereas there having been presented to me the Honorable Jennifer Johnson Mitchell, Judge of Division 10 of the Criminal Court of Tennessee, 30th Judicial District, at Memphis for the purpose of trial, sound bites from police with witnesses. The sound bites are stipulated by the Assistant District Attorney and Attorney for the defendant, Amanda Sylvan, and shall be entered into the essence by this agreement, signed by the District Attorney and Attorney for the defendant. And this, the sound bites are captured on a black zip drive in a brown envelope that I'm going to place on here. Police soundbite, police interview soundbite.
Yes, sir.
Of Angela Arnold, because this is just of Angela Arnold.
It's all of it, Your Honor. It's Angela Arnold, Cornelius Smith, and Detective Brown.
All right, police. Of Angela Arnold, Cornelius Smith, and who's the third person?
Detective Brown, Your Honor.
Oh, this one. Jesse. I put this down, it's down like this, and A Arnold, is the respective symbol. Little mark, this is exhibit, collective exhibit. 33. Have you had an opportunity to look at the jury chocolate? Well, you need to take a few minutes, because we don't charge these jury like after lunch. That was give them time to re-review it, and then we'll come back and talk about it on the record, make sure it includes everything you need to include, make sure that have anything in it that you need to keep that. And that'll get, be time to get it printed, and I'll charge you after lunch, from probably about 1:30.
So this,
Okay.
3.03.
Um. And to both. Wait. Objection to that. All right, well, I'll add that, I'm gonna go back and add the other expert. I just added the Canterbury, I'm gonna add the doctor just testified. And the stipulations. Okay, so I mean, I'm not that one. Look at it, let me know, okay?
so this sounds like a working lunch.
Recess?
No, not for y'all.
Okay.
I mean, I need to know, probably within the next 30 minutes or so, if you think the charge is complete. I need to know what you think about the charge.
I think we're all good except for what we just mentioned.
Okay. So you have review.
Yeah, we pretty much, okay.
But so, no, let's say 12 o'clock for lawyers. So we can make sure it looks like it should look. And then we'll, probably recess to 1:30. But I think lunch is coming somewhere in that time. Okay? Okay.
Okay, so they are going to be on recess till I forgot. I don't know. Until 12 o'clock, which will be 11 o'clock their time. Well, 12 o'clock will be 1 o'clock my time. So that's a half an hour from now. She's giving herself time to incorporate accessory after the fact. So let's look up Tennessee's accessory after the fact, which is giving an out to the jurors because if they believe any of the testimony of Cornelius Smith, they could conclude or come to a reasonable opinion that Mr. Hernandez Colvin participated in the crime, but it was accessory after the fact. So let us look that up and see what it looks like. So yesterday I was over here in this Tennessee lore. So first let me come over here to me. Let me take this off the screen because if we don't need it, we're not going to use it. We'll keep the sound on so that if they return, we'll be able to come back in here. And we're going to look up Tennessee so it's TCA um what is it? Accessory after the fact. Let's see if this thing can find it over here since we on here. Okay, accessory after the fact is Tennessee Code 39. It's section 3911-411. So let me first I'm writing sticky notes today because I gotta put them in my notebook, but I wanted to make sure that I'll be writing frivolously in my notebook. Some of these facts, because you know they come out sporadically. So let me see. Rest case. Next thing is TCA section 39-11 part 4. We're gonna leave it like that. A person is an accessory. Well, let's go here. Okay. So it is 411. A person is an accessory after the fact who, after the commission of a felony, with knowledge or reasonable ground to believe that the offender has committed the felony and with the intent to hinder the arrest, trial, conviction, or punishment of the offender, harbors or conceals the offender. So, I think that this comes into play because he contends that there was a meeting, he being defendant, co-conspirator, Cornelius Smith contends that there was a meeting sometime the after the incident at a car wash. Um, so provides or aids in providing the offender with any means of avoiding arrest, trial, conviction, or punishment. Now, they can easily find that to be the case based on some things that Cornelius said, if you tend to believe Cornelius. Um, and this is why they put forward witnesses to dispute um or to challenge or to discredit or to rebut some of the statements that came from Cornelius himself. Warns the offender of, in the other part of accessory after the fact is they warns the offender of impending apprehension or discovery. We do know that in this case, right, one of the co-conspirators or one of the co-defendants in the case, the brother of Justin Johnson, who is known as Straight Drop, Jamarcus Johnson was charged with that accessory. He was charged with accessory after the fact and provided with 6 years of probation. This section shall have no application to an attorney providing legal services. Accessory after fact is a Class E felony. So it tells you the level of felony it is. So it's after the commission. So a person is an accessory after the fact who, after the commission of a felony, so murder is a felony, with knowledge or reasonable ground to believe that the offender, which would have been Mr. Cornelius Smith himself, committed the felony and with the intent to hinder the arrest, trial, or conviction or punishment of the offender. So that would be, meeting him at the gas station, talking to, well, it wasn't a gas station, it was a car wash, providing him with funds so that he can avoid a capture or, so I think the defense has introduced this as a option because maybe someone may view his actions as being just that, actions of someone who helped and aided somebody who was avoiding the police, but not necessarily someone who co-conspired with the person and was going to give them what was willing to take $10,000 as his cut of the transaction, nor did I see, maybe someone else saw something I didn't see, any communications that corroborated that there was a $10,000 agreement between which that kind of agreement is considered a conspiracy because it's not a lawful agreement, but it's something that people that are committing crimes engage in or come to terms with. So that's where we are at in that aspect of the case. Now, what I do not see in here is the penalty. So let me go back to this section. Let me go back. I might have to look up Class E felonies in 3911. Plus, we don't know which one that they entered into. But here they have criminal responsibility, and this is so we just read part 411, but there is a section 3911-403, which is part 403. Criminal responsibility for facilitation of felony. A person is criminally responsible for the facilitation of a felony if knowing the other intends to commit a specific felony, but without the intent required for criminal responsibility under Section 3911-402, subsection 2, the person knowingly furnishes substantial assistance in the commission of the felony. The facilitation of the commission of a felony is an offense of the class next below the felony facilitated by the person so charged. All right, so we'll have to see which one they picked. Let me see. Criminal responsibility for conduct of another. A person is criminally responsible for an offense committed by the conduct of another if no. No, I don't think that's applicable, so I doubt they picked that one. So it says parties to the offense. A person is criminally responsible. So we're now in Section 39 of the TCA, 11 Part 401, parties to the offense. A person is criminally responsible as a party to an offense if the offense is committed by the person's own conduct, by the conduct of another for which the person is criminally responsible, or by both. Each party to an offense may be charged with commission of the offense. That sounds like something you would put when somebody has jurisdiction over another person. So I don't think it's applicable. I'll go with part 411. Maybe there's a 401. Not 401, whatever the other number was that I came across. But what I do not see is the penalty. They did say it's a Class E felony. Let me come over here and look for let me see. So we know we're dealing with TCA section. Oh, it don't let me do section. All right, 39 dash 39 dash 11 dash part 4, and we want to know the penalty. Let's see. After the fact, it's a Class E felony. All right, so let's see. Tennessee Class E felony. Okay, for a Class E felony, not less than 2, no more than 4 years. So with that charge, it would be 2 to 4 years of incarceration. And this man was out on bail. So he would have to do 2 to 4 years if he was found guilty of that. 2 years to 4 years. For a Class E felony. All right, while I'm here, I want to look up this conspiracy stuff again. But I think I did yesterday. I think we discovered that it's a long damn time. It was a lot of time one would get. All right, let me see. Did I turn this off? No, I didn't. Okay, so that's it. I'm just looking through emails. Oh, I'll just mute that from January to be the same. Okay, so that is that. Um, the news is seeming to report on this, but we're not taking anybody else's commentary on this stream. If you're welcome to go to channel 24 and get their opine on it. Me myself, I don't really like listening to everybody's narratives on stuff until after the fact. I like to have my own clean, fresh mind. Cause for me, I'm the 14th juror over here, and I don't need my thoughts to be persuaded by other people's thoughts on anything. I like to take my limited knowledge of something and apply it to what's happening now. And I guess it's their news time or what have you. Hopefully they come back to this feed. Oh, they have it in the corner, so I guess they're gonna cover some other stuff and then pull it out of the corner. So we gonna keep from keeping those people's business in our forefront. Anyway, and let me make sure that I've been trying to mark this stuff because I think in the future I might want to take some stuff off or figure out where I can cut videos down to make them make sense in the aftermath. In the meantime, between time, I'm over here steady moving along with my crochet project over here. It's good to have something else to do. I finished another project, but I was just speaking to somebody in text message and we was talking about how I could improve that one and I might take out that piece and make my correction on it um later this evening. But I have to see how much interest I need to add to stuff. That's another thing. Like, I really need to start measuring stuff and writing down my patterns so I can repeat. I could repeat stuff because this little insert right here, I know I'm gonna love it. I remember coming on here and making a poncho, a carry bag for my notebooks once upon a crime. I mean, if I wasn't doing this right now, I would be mopping, I would be doing some house chores around here. So, but I'll probably do that while they on verdict watch. And then after we hear the testimony, after the judge charges them after lunch and gives the jurors the case, then I will go and shut this down and use that symbol that we've been using and make oh, I might not even need to make a thing, but I will make a verdict watch for this and take it from there and see how long it takes. Now, I don't think the case wasn't that long. It virtually was put on in 2 days because this case started on Monday. They had Monday, they had Tuesday, and today's Wednesday. We could get a verdict today or sometimes tomorrow morning. Most likely, if they are charged today, we probably will get a verdict today. Because I don't see where this is too complex, but we have to listen to the law. As the judge said, the law will come from her. Ooh. And I was just up here reading the stuff and telling y'all what it could be. The reason why you can't ever find what the penalty is because they don't want the people, the jurors who are deliberating to be concerned with what the penalty is going to be or what the penalty may be. So that's extremely interesting. All right, I'm just steady moving along with my thing. Oh, I be forgetting to add my count over here. I gotta be more mindful of that when I go around. Boom, boom. I'm gonna say that. But I don't know, cause this looks like it's. I don't know what the. I'm gonna go with my count over there, but I'm gonna stop at 30 because it's supposed to be at 50. Stopping to put the but I don't think I need to go that high. So I'm gonna stop at 30, going around 30 times to then put the handles in. And that's it. So they should be back in the next 10-15 minutes. Who is this young man? Oh, that's Abrigo Garcia. Man, they got him for trafficking. I knew I've seen this man before. Man, listen. I know one thing who I ain't seen out here. I don't know. That case is suspicious. Just suspicious. I'm starting to feel like the young lady who said she was shadow banned. I was just telling somebody today, I think I'm gonna take all my little crafts and go to a what do you call it? Get me a table somewhere and sell my little crafts. Man, these people be crazy to me. Wait a minute, wait a minute. Oh yeah. Do 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 do. They look like they got the seal back up. So let's see if they. And that's it. I know the Donald Adelson trial is also today, but I don't want to be like jumping around trials. I wish I could have went back. I'm waiting for them to do this part and say it's okay. Then see what time she's gonna charge the jurors, and then depending on that, we'll go back and listen to the police officer's testimony from yesterday that I did not cover, and then see if we go back and listen to the testimony of the witness if we have time of the other co-conspirator. And that's that. Let me see. So you should always take your stuff to trial. Learned that the hard way. Well, 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 well. Mary had a little lamb, little lamb, little lamb. This feels so nice. Let me see. I'm over here in my little bag. Let me see. I'm nowhere near where I want to be at. Oh yeah, that looks really nice. I probably could have went a little bit wider, but hold up. Let me roll up. Oh, that's so cute. Oh, that's coming out so cute. All right. That is coming out so cute. Now I wish it was the other. I wish I would have done the other color. But besides making it black, because you know, inside a bag could be a whole what do you call it? A whole dark hole. But this is coming along very nicely. For those of you just joining us, we are waiting for the judge to resume with reviewing the charging document that's going to go before the jurors, because she is going to charge the jury after lunch. It sounds like sometime around 1:30 their time, maybe around 2:30 my time or 3 o'clock. I was hoping to leave at 3 o'clock, but maybe today I'll be leaving at 4 if she begins to charge them. It looks like there's activity going on in the courtroom, so we're gonna resume our coverage as soon as I hear something. I'll put it back on the screen. Do, 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 do. It's a rainy day in New York today. Okay, the judge is back on the bench.
I think I did it already, accessory after the fact.
Oh, right. So I'm adding,
That's right.
the state didn't have an issue with that. I think you asked for that too. Okay. They also asked that I include solicitation to vote the conspiracy and
Now they adding stuff.
adding. Well,
I can't go all or nothing.
no, can't do all or nothing. Court of appeals might not like that if they have to review it.
Even if I wait.
Yeah. They can do so. If y'all agree, if you agree, I think I might be able to get away with it, but somebody's gonna be unhappy with that. One party or the other is gonna be unhappy, it's like, it's bad for those ways to move.
Don't she seem so pleasant?
Adding solicitation to both the conspiracy and first degree murder. And I'm adding, accessory after that to both also. On page 5, in the definition of conspiracy to commit first degree murder, in paragraph 2, that, the second part to that was actually the definition of first degree murder. I'm scratching that kind of confuses things. So paragraph 2 will read that each of the parties to the conspiracy has the intent to commit the offense of first degree murder. Okay? I did add the stipulation. I added the experts. I took out the defendant testifying. So let's go back to this for the people. On page 4, where I list the.
They are working through the charges.
Of course, I'm gonna add. And it comes to count 2. I've added solicitation to first degree murder, second degree murder, aggravated assault. Do I need to plead on the assault? Then starting abundance of caution, or y'all do it if I don't? I just kind of feel like open to it, you get that stuff. Okay, so the parties agree, I will leave it off for assault. Assault is the last offense there. Okay? Anything else?
It wasn't an assault, it was a murder.
Maybe state my life, your presence.
Who?
Mere presence, discussion,
As for the conspiracy,
after the conspiracy.
it's in a definition somewhere.
Thank you.
Hold on, part of the definition. I think it's probably in the conspiracy definition.
Okay, if it's there, that's fine.
Hold on.
Page 18, page 18, there.
In what? And now I've added a bunch of stuff. And what is it a part of it?
So it's under the criminal responsibility for conduct in another section, right above the conflict.
Okay. Yeah.
So that means y'all ain't read this thing.
However, mere presence from the commission of offense is not sufficient to support a conviction.
Ooh, that was serious. That is definitely serious.
All right.
And then between closing for me a second to switch to.
That's fine. Do I need to put a time limit on closing argument? Don't.
Oh, damn, I done forgot about closing argument.
Okay.
Figured fairly throughout. I haven't had to clear my throat and look at you on, so.
That's what I was keeping back to you.
Right. I think I know of ways to get your attention, and I don't want to have to.
I don't want to go long.
And I'm going to give you the opportunity to present your case. I'm not afraid to step on that. Just when I start doing the same thing over and over again, I get restless, and that's just.
I'm doing that until I really screwed it up.
Right. Okay. Well, good.
So cordial.
Let's stand in recess to 1:30.
Was in recess to 1:30.
Okay, so they in recess to 1:30, which will be 2:30 my time. So what I'm going to do is I'm gonna end this stream. I'm gonna come back at 2:30. I'm gonna name this closing arguments and come back at 2:30. Those of you who want to join me, feel free to join me. Anyway, this is Mo. I've got to go.